Recording. Welcome to today's virtual seminar, I Care a Lot, Separating Fact from Fiction in Controversial Conservatorship and Trustee Matters. Presented by NM Law's expert legal panel, Noelle Minto, Samantha Smith, and Stefan O'Grady, this seminar aims to separate fact from fiction, outlining exactly how to protect oneself from this type of abuse while planning ahead of time for this type of care should it be required in the future. With over $1 billion of assets planned for and protected, Ms. Minto and her team have positively represented hundreds of families and generations. And with that, I have the pleasure of introducing our panelists. Since 2003, Ms. Minto has been an estate and business transactional attorney based in Orange County, California. Her practice represents high net worth individuals and privately held business entities based throughout the United States and abroad. Ms. Minto has assisted clients in crafting comprehensive estate plans and maintaining business structures to address each family's specific needs, including everything from revocable trust to the formation of charitable entities, including public charities, private foundations, and a myriad of estate planning tools. Once an estate plan is implemented, Ms. Minto and her team continue to support clients with any ongoing compliance and coordinate with each client's circle of advisors. When needed, NM Law facilitates annual family meetings, corporate maintenance, and assisting with transitional time periods brought on by retirement, incapacity, liquidating events, and ultimately administration upon the death of a settler. Our next panelist is Samantha Smith, who is an associate attorney at NM Law and a native of Orange County. She is a member of the California Bar and Nevada Bar. Ms. Smith's practice specifically focuses on trust administration, trust litigation, and probate proceedings. She represents executors, administrators, settlers, trustees, and beneficiaries to help administer trust and probate estates and to help solve disputes relating to estate planning documents such as a will or a trust or a person's mental capacity. Ms. Smith is a member of the board of directors of the Orange County Bar Association Trust and Estate Section. She's recognized as a rising star by super lawyers for the past 3 years. Samantha enjoys traveling with her husband to new places and running with her Australian Shepherds. And last but not least, our last panelist is Stefan O'Grady, who is a senior litigation counsel to the firm, where his practice focuses on probate and trust litigation. Stefan represents beneficiaries and fiduciaries, both professional and non-professional, in contested and non-contested probate, trust, conservatorship, and guardianship matters. Stefan is a past president and a member of the Board of Governors of the Century City Bar Association, and a member of the Trust and Estate section of the Los Angeles County, the Beverly Hills, and the Orange County Bar Association, as well as the State Bar of California. Stefan is a graduate of the University of San Diego School of Law and holds a Master's of Business Administration from the University of San Diego School of Business Administration. In his free time, Stefan enjoys staying active and spending time with his wife and his corgi, Terry. He is a passionate soccer fan, and you can find him at the LA Galaxy home games during the season. And with that, I will pass the mic over to Noelle Minto to take it from here.
Good afternoon, everybody, and thanks for joining. If you haven't had the pleasure, or rather displeasure, of watching the movie on Netflix that was released earlier this year called I Care a Lot, have no fear. You don't need to be familiar with all of the movie in order to understand the content of what we're going to be discussing today. And it is sort of the most egregious example of what can go wrong when you lose control over your estate to somebody who is not trustworthy or somebody who's a bad actor. So we are going to be playing just a little clip to give you a little flavor and overview of what that movie is about. And we'll be doing that a couple of times throughout today's lecture. So let's go ahead and start with this first clip, and then we'll jump right into today's presentation. Not something you'd see occur. Now, where this is factual is the fact that, you know, if there's infighting and people are not putting first the considerations of the elderly person or disabled person that needs someone to look over them, and they're instead trying to save for their future inheritance or maybe not, you know, attending to their medical needs, then you could have a situation where someone else, perhaps someone of the court's choosing, is appointed to look after the best interest of the person who needs assistance. So sort of, like I said, a little blend of everything, but you know, this is a real life situation where there's someone who needs a caregiver, or at least that's the story that she's telling. So today, our material is really going to be focusing on protecting families and their assets from bad which is called a conservator in the state of California. But she could also very well be a trustee or an agent under a durable power of attorney. So the language fiduciary is general. And while we'll be citing a lot of the probate code sections and laws that apply to trustees, because that's most relevant to a greatest number of people, a lot of these fiduciary standards are across the board for conservators and for agents acting under a durable power of attorney. So we're going to be breaking this presentation down into three main sections today. First, we're going to have Samantha Smith, who practices predominantly in a situation where somebody's administering a trust. And then we're going to have Stefan O'Grady, who does trust litigation, almost exclusively trust petition work, talking about what happens when you do have someone who's breached their duties, or you've got a document that you don't know what to do with because it's unclear. He's going to specifically be talking about when you're intervening through court. And then I'm going to be talking about, I'm the silver lining at the end. I'm going to be talking about drafting in order to protect yourself and your family from ever having to deal with hopefully the court process. So let's go to the next slide real quickly before we jump in. The Professional Fiduciary Association of California is the governing body, so to speak, for these private professional fiduciaries. Okay, and this is a really large group of people, and it's growing because the need for having a third option, right? Not a bank, and not perhaps your family member or your neighbor next door. These fiduciaries, these private professionals, are filling in and trying to meet the needs of what Californians need. So just to give you some staggering numbers here, $20 billion is what these private professionals have under their control in the state of California. They represent 4,900, almost 5,000 conservator of the estate, which is again something that's appointed through a court. And then almost the same number, 4,500 individuals are appointed as conservators of the person right now. So that's when they control perhaps where you live, but your medical care and so on. And then they are acting as trustees in over 4,000 trusts in the state of California, which associated with that, that means they're managing about 3,000 real properties. So this is a big industry and it's growing every day. Okay, so I'm going to turn it over to Samantha Smith, who's going to be walking us through common mistakes that fiduciaries make when administering a trust, and she'll be talking a little bit about estates as well. Samantha?
Thank you, Noelle. And before we get into the most common mistakes that we see trustees make when administering a trust, we wanted to take a poll to find out about how many of you here today have served as a trustee or executor in the past. So we'll give everyone a minute or two to please take the poll that has popped up. Okay, it looks like about 22% of the participants today have served as a trustee or executor before, and the rest have not. So that's very good. Thank you for taking the poll. And those of you who have served, we can go to the next slide, please. And those of you who have served as a trustee or fiduciary in the past, you probably know that some of these trustee duties, which are provided under the probate code sections 16,000 to 16,015. And we put up some examples here on the slide. First and foremost, the trustee's duty is to administer the trust according to the trust instruments. So this is why it's really important for a trustee to at least consult with an attorney when they start working on administering the trust, when it first becomes irrevocable, to make sure that they understand the trust terms and interpret the trust terms correctly to be able to follow the trust terms properly. The next trustee duty is to provide the trust beneficiaries with a copy of the trust once it becomes irrevocable and upon any request by the beneficiary. The trustee also needs to keep the trust beneficiaries reasonably informed about the trust administration throughout the entire administration. And the trustee needs to account to the beneficiaries at least annually at the termination of a trust or upon any change of trustee. The trustee needs to make trust property productive, provided in probate code section 16007. This means that the trustee needs to rent, invest, or sell trust assets so that the trust is not losing out on the opportunity to earn income. The trustee needs to deal with trust beneficiaries impartially under probate code section 16003. This means treating all beneficiaries equally and not advocating for any one beneficiary's interest or a position over another beneficiary's. Stefan O'Grady is going to be presenting a little later this afternoon, and he will be explaining what a trustee can do to sort of break the beneficiary deadlock or any sort of dispute between beneficiaries regarding how a trust should be interpreted. And the trustee does not want to use or deal with trust property for their own profit or for any other purpose that's unconnected with the trust. And lastly, the trustee just wants to always take reasonable steps to preserve and protect trust property. So now that we have sort of an idea of what the trustee's duties are, which are very similar to an executor's duty who's going to be administering a probate estate through the court, we can now turn to the first most common mistake that we see trustees make. And that is not providing the required notice under section 16061.7 to the beneficiaries. Failure to provide this required notice to the beneficiaries is a breach of the probate code, so it's a violation of the law. And the trustee wants to provide this notice as soon as possible because it starts a time period in which the recipients of the notice can bring claims and actions to contest the trust documents. Usually these claims and actions would be on the basis of the trustor not having capacity or maybe being unduly influenced by one of the beneficiaries to change their trust documents to favor that beneficiary who did the influencing. By failing to give the notice, the trustee is not going to put this contest period into play. The contest period is not going to start to run. And so that's why it's important. The trustee wants to give the notice right away in order to know whether any of the beneficiaries or maybe even the decedent's heirs have any concerns or objections to the validity of the trust documents. The last thing the trustee wants to do is start administering a trust and then find out, months later that one of the beneficiaries or maybe an heir who is disinherited, has some sort of concern about the validity of the trust documents. Turning to the next most common mistake we see is trustees will sometimes not provide that date of death inventory of trust assets to the beneficiaries. So just depending on the circumstances, this date of death inventory of the assets should be provided within a few weeks to a couple months of the trust becoming irrevocable. So after the trustor passes away, if there are assets that need the trustee's immediate attention, such as a home with a reverse mortgage against it, or maybe one that's in foreclosure, or when the beneficiaries or heirs are, demanding information and disclosures, It's best to get this date of death inventory out right away, so the beneficiaries know, what the estate assets are, what the trust assets are, and that the trustee is working on them, because the inventory should include, all assets, of course, accounts receivable, accounts payable, liabilities, and debts. And then on the flip side of that coin, it's okay if the trustee waits a few months to get the date of death inventory out in a situation where maybe all the trust beneficiaries are all getting along and they are not any assets that need the trustee's immediate attention. It's okay for the trustee to wait maybe a few months to get this date of death inventory out. It just sort of depends on the circumstances. And then if a trustee fails to provide this date of death inventory, it's a breach of the probate code to keep, and their fiduciary duty to keep the beneficiaries reasonably informed of the trust and their administration of the trust. It can also create some distrust or paranoia among the beneficiaries who may expect the trustee to, start selling or distributing trust assets right away, which just might not be possible until some interim steps are taken, depending on the types of assets and other variables. So turning to the next slide, in order to complete the date of death inventory, the trustee is going to need to get some date of death appraisals, especially for real estate. Many assets, such as real estate, need to have these date of death valuations in order for taxes to be correctly prepared and reported. If a trustee fails to obtain these date of death appraisals, the CPA or other tax preparer may not have the proper information they need to correctly report taxes to the IRS, which can cause tax liability for the trust. It's important to, report these date of death values correctly, because it has to do with, it's a way to capture what the step-up basis value is. So those of you who may not know, basis value is essentially the cost value of an asset. So it's what you purchased the asset for, the value that you receive the asset for. So when somebody receives an asset upon death, through inheritance, they're going to enjoy what's called a step up in the basis value. So they're going to get the asset with a basis value of the date of death value of that asset. And so the IRS has 3 years to audit the trust tax returns to determine if they were reported correctly. And if an audit does happen, the trustee definitely needs to have those date of death appraisals to produce to the auditor, and especially if the estate value is, close to the federal exemption amount that year. Turning to the next slide, please. Another very common trustee breach that we find and common mistake that we see trustees make is not providing full and complete financial records to the trust beneficiaries. Beneficiaries have a right to these full and complete financial disclosures of the trust assets and records, because the trustee's administration is supposed to be essentially transparent, meaning that these beneficiaries have a right to see tax returns, bank statements, copies of checks, withdrawal slips, things like that, deposit slips. And oftentimes when a trustee may be, starting to administer the trust without the advice of counsel, they'll come into our office and, they may think that they can sort of pick and choose which financial disclosures they need to provide to the beneficiaries, which is just not correct. And it can oftentimes get the trustee into legal trouble if they take, an early position that is going to be adverse to their legal duties to the trust beneficiaries.
So Samantha, I have a question related to that. I know this issue comes up quite often. What advice would you give to any beneficiary if they're not really receiving financial disclosures? Is there something that they can do in order to, force them to provide some sort of information?
Yes, if a beneficiary is not receiving the financial disclosures that they are entitled to, they want to make a written demand to the trustee that they provide a, probate code accounting, and the trustee has 60 days to produce that accounting to the beneficiaries. If the trustee fails to get that accounting, to the beneficiary who demands it in writing within that 60-day period, then the probate code section, which Stefan's going to be providing here in a little bit, allows the beneficiary to file a petition in the court to get a court order that the trustee, serve and file that accounting. And then if the trust or the beneficiaries don't agree with anything in the accounting, or if they have objections, that would allow them the opportunity to file those objections, and then the issue of the accounting would be litigated.
Okay, and what about the opposite circumstance where everybody's kumbaya, everybody trusts one another, and they don't necessarily want or need something formal? Are there other options for people like that, depending on what the trust says?
Yeah, so oftentimes when we represent trustees, we sort of take the temperature of what the beneficiary's relationship with the trustee is. If there's any sort of, indication that the beneficiaries have concerns or objections, or, if they have distrust among them and they don't trust the trustee, then we would advise to get court approval of the accounting, because that is the trustee's best form of defense to, defending later claims that can be brought 5, 10, 15 years in the future against those claims. So that's the best. A court approval of accounting is the trustee's best form of defense. If everyone's all getting along, then typically we advise trustees, court approval might not be necessary or in the best interest of the trust and the beneficiaries. In that case, we would provide financial disclosures, all those documents that I referenced before: bank statements, copies of checks, tax returns. And we provide them to the beneficiaries and let them know that it's being provided to them pursuant to probate code sections 16061 through 16064. And we ask the beneficiaries sign waivers of accounting and release of claims against the trustee. And what that does, by providing them those financial disclosures, that starts a 3-year statute of limitations for them to bring claims. Although the trust document itself can limit that 3 years to 180 days. So just depending on the circumstances, it's not always advisable to get court approval of accounting, but it is a really good option and defense for the trustee.
Thank you.
And then I just wanted to make and we can go back to the slide, but I wanted to make draw a similarity to the movie. In the movie, for those who have seen it, Marla Grayson in the video, she finds some diamonds in the wards in her conservatee's safety deposit box. And she takes them home and tells her girlfriend that she does not plan to include these diamonds on an inventory because she suspects, they sort of might be stolen, or they might not have been inventoried by the conservatee herself. So that would be a clear, violation of the trustee's duty to provide these financial disclosures to the beneficiaries. And she, it would be a breach of her duty to provide the inventory of the trust assets to the beneficiaries. We'll go to the next slide, please. Another common mistake that we see trustees make is paying all of the decedent's debts or creditors. So I first have to draw a distinction between, a probate administration, which is through the courts, and then a trust administration. So when we have a probate administration, the probate code is going to require that the executor provide a mandatory notice to all known or suspected creditors of the estate, and they have about 4 months to make claims against the estate. So of course, that probate is not required typically when we have a trust and we're administering a trust. So, some trustee clients will come into our office a few months after they've been, administering the trust, after their parent dies, and they may tell us that they have paid a handful of their parents' credit card or medical debts off. And much to their dismay, we have to advise them that children are not legally responsible for paying their parents' debts. And typically when a parent has a trust, their assets and their assets are in the trust, children can avoid having to pay these debts like credit card bills, medical debts. And most trusts have spendthrift provisions, which limit a creditor's ability to collect a debt from a trust that the debtor has an interest in. So this is part of how we help our trustee clients. We help them locate and deal with trust debts and save, our goal is to save as much money as possible to be distributed to the beneficiaries. And with that, I wanted to turn next to 2 really common examples of trustee breaches that we see oftentimes. So the first one is when a trustee, or it could be a beneficiary, they live in or use trust property as their own. So this happens quite often when it could be a beneficiary or trustee, maybe they were living with mom or dad who's elderly, and they were providing, caregiving services for mom or dad, and maybe they were not paying rent because it was sort of a compensation, an offset of them providing the caregiving services. But as soon as mom and dad passes away, that person living in the home, beneficiary or trustee, they are legally responsible for paying their proportionate share of the fair market rental value to the trust for each day that they're living in the property. So for the trustee to live in the property and not pay rent to the trust, it's a clear breach of their duty to avoid conflicts of interest. And it's probably going to be a breach of the trust document itself in most cases. And it's just a really common misconception that the trust beneficiary, who is living with the trustor while they're living, and now, they've passed away, they oftentimes think that they can continue living there without paying rent, and the court does not agree. The second most common example that we see a lot is a trustee who makes loans of trust money to themselves, or they loan money to the trust. This is typically going to be a breach of the trustee's fiduciary duty to avoid conflicts of interest and, avoid commingling of assets. However, some trusts will allow for this as long as the transaction is in good faith. The trustee pays interest for any loans that they make to themselves, and the money, or if the loan is necessary or in the best interest of the trust. One common example we see is if the trust only has a piece of real estate but no cash accounts, and the trustee, needs to pay mortgage, property taxes, insurance in order to, keep the house afloat and not go into foreclosure while they work to sell it or while we work on administering the trust. If in this situation, if a trustee is going to make a loan to the trust, they're going to be entitled to reimbursement. And depending on what the trust document says, oftentimes we can also have them be paid interest on the reimbursement amount. And then I would like to go to my last slide here is when a trustee or beneficiary should consult with or hire legal counsel. So first, a trustee should consult with an attorney right away when they start to administer the trust. An attorney